case number 09-CR1064. Have some motions this morning. Will the parties state their appearances for the record?
May it please the Court, the State of Kansas appears through Assistant District Attorney Mike Nichols.
Your Honor, the defendant, Adam Bloomdahl, appears in person by and through counsel Steve Alexander.
Yes, sir.
Your Honor, this is my motion to withdraw from representation of Mr. Bloomdahl. Before I get into the merits of the motion, may I inquire of Mr. Bloomdahl whether or not he has any objection to my being allowed to withdraw?
I would have an objection, Your Honor.
Then because of that, Your Honor, as the motion indicates, there are fundamental differences between Mr. Bloomdahl and I on how to conduct the defense of his case. I'm asserting a breach of our employment agreement regarding the retention of experts. Also, Mr. Bloomdahl is pressing me to present a defense in this matter that I feel is not going to be justified by the facts of the case and the case law. Mr. Bloomdahl was first involved in this case when the information was filed back in July of last year. In September of last year, I entered my appearance. At the time I entered my appearance, Mr. Bloomdahl and I agreed that my fee would be a very modest fee. I offered to deduct 50% off my regular fee because of Adam's service to our country, because he had a disability, and because this is an arson case, I recognized and explained to him that in all likelihood we would have to retain experts with regard to fire causation and possibly a medical professional because of behavior of Mr. Bloomdahl following the fire and because of his disability. Mr. Bloomdahl advised me that he had sufficient resources to retain experts in this matter. Therefore, we entered into an employment agreement. By the terms of the employment agreement, Mr. Bloomdahl would agree to pay all necessary expenses, which in my opinion will assist in the defense of the case. This would include the retention of necessary experts. The agreement further reserved my right to withdraw should Mr. Bloomdahl fail to abide by any of the terms of our agreement or cooperate with my representation. Now, even though this case, Your Honor, was filed about a year ago, I got into the case in September. I immediately submitted my discovery request and received initial discovery in this matter in October of last year. We had a preliminary hearing in December of last year, but unfortunately, it took about 7 months for additional discovery because of the large record and the nature and extent of the investigation to receive the additional discovery that I had requested so that we could review this matter with one or more experts. In April of this year, April the 26th, I received over 500 pages of materials, and on the 1st of May of this year, I received 7 DVD-R discovery discs that contain scene photos and audio statements. In April of this year, having just received the discovery, I filed a motion for trial continuance and a motion for deadline to select experts and for further discovery. Now, we were able to locate an expert in May of this year, Mr. Kurt Huckshorn of Huckshorn Consulting. Mr. Bloomdahl retained Mr. Huckshorn the end of May of this year. But following a meeting on June the 12th of this year, Mr. Bloomdahl canceled his services. In June of this year, June the 24th, my client acknowledged in an email to me that he lacked funds to hire experts and he was wanting to assert a new defense. I filed my motion to withdraw on June the 25th, received a telephone conversation with him on June the 28th, wanting a meeting with me. We met at the Wyandotte County Courthouse. Mr. Bloomdahl advanced what he thought his new defense would be. I indicated that I didn't think it was going to be a credible defense. Mr. Bloomdahl became very upset with me, yelled at me in the hallway, indicated that because he had paid me funds, I must go ahead and defend him with regard to his theory. For the reason that there's obviously a fundamental difference on how to proceed with Mr. Bloomdahl in terms of case management, I have filed my motion to withdraw.
Yes, sir.
Your Honor, just briefly, if I may, if I guess they're going to get into any
We're not going to get into
Okay.
no. We're not going to get into specifics of defense.
Okay.
Based upon what counsel has told me, he's indicated that ethically he can't go forward with a particular defense espoused by the defendant, and that's as far as we're going to go into the details.
Your Honor, according to our agreement, which I have right in front of me, it does not specify on behalf of Stephen Alexander what precisely should be defended according to experts in light of a number of issues, financial situation, etc. I focused on the beginnings of this case, and I have what I believe a valid defense, which is supported by documentation that the insurance company was.
Your Honor, may I interject?
Yeah.
I believe he's about ready to get into the
Yeah,
nature
I
of his
just don't want
The
defense.
nature of your defense is not what's an issue. Now, I'll tell you what I think's going on based upon what Mr. Alexander has just told me, and that is that he can't go forward with the defense you have suggested for ethical and legal reasons. Now, I don't know how many arson cases you've defended. I don't know how many criminal cases you've defended. But I'm going to rely on a seasoned veteran criminal defense attorney's assessment of the facts and issues in this case. He's obligated to espouse any defense which has a legal or a factual foundation. Absent that, he's under no obligation to proceed with something that would violate either of those. Now, I don't want to know what your defense is going to be.
Well, what I'd like to
Just listen to
Yes,
me
Your
for
Honor.
a second.
Of course.
Okay, I don't want to know what your defense is going to be, but this appears to be the problem. He's choosing, for a couple of reasons that he's already stated, he's not going to go forward with that particular defense. If you insist on that particular avenue, then the two of you are going to have a problem, and you're going to have to start again from scratch. The whole idea of hiring an attorney is so that you can rely upon his advice, his counsel. You may think you have, a great defense, but if it's not couched in the law, and if it's not couched in facts and evidence that are admissible, won't matter. Doesn't matter. Won't come into evidence. Now, let me just, is what I just described fairly accurate summary? You have a defense that you think is viable. Mr. Alexander disagrees, and that's what the problem is. Is that a fair statement?
Your Honor, I disagree. I believe that at this point he is trying to withdraw from the case because he feels that at this point the defense that I'm trying to present is not worth it to him to continue to present it.
That's not what he said on the record, but I appreciate that's where you're coming from. It would appear to me there's a pretty severe and serious conflict if you insist upon this particular defense. What it means is you're going to have to get a new attorney. I'm going to grant his motion to withdraw. How much time do you think you're going to need to...
Well, Your Honor, I'd have to file an indigent because I do not have any more money at this point. I live on a fixed income, and that money is going to pay bills for my child.
The procedure, generally speaking, is if you need appointed counsel, then your bond is revoked and you're put in jail, and then you're appointed counsel. I'm going to give you
Okay, sir. Yeah.
a
Yes,
short
Your Honor.
amount of time. I'm going to give you a week to decide what you're going to do in this case. I need to see you at 9 o'clock next Monday. That's the 19th, if I'm not mistaken. And then you need to tell me whether I'm going to have to revoke your bond and appoint counsel, or you can hire your own counsel. Those are the only two issues I'm concerned with at that time.
So you're telling me if I have to get state-appointed counsel, then I'd have to be in jail?
Your bond would be revoked. Yes, sir. So, 19th, 9 o'clock. You give me an order, I'll sign the
Yes, sir. I'll
same.
prepare one today.
But your motion is granted.
Thank you.
We're adjourned.